On March 20th, 2025, a routine shopping trip in a Harris County parking lot turned into a felony investigation. Witnesses described a suspect in a camouflage hoodie triggering a car alarm, waiting for it to stop, then returning to force entry into the vehicle, fleeing only when the owner approached. Police didn't need a confession. Under Texas Constitution Article 1, Sections 15 to 17, and Texas Code of Criminal Procedure Article 15.26, an arrest and continued detention can be justified on probable cause alone, facts strong enough to suggest a crime occurred and that the accused may be responsible. Witness statements, surveillance images, a fleeing vehicle, and burglary tools recovered during the stop all became part of that probable cause analysis, the same legal standard judges rely on at the earliest stage of a criminal case. Now the courtroom must decide. Does this evidence meet the constitutional threshold to restrict liberty, impose bond conditions, and place a defendant under electronic monitoring? Because in Texas courts, probable cause, not proof beyond a reasonable doubt, is all it takes to change someone's freedom overnight.
You are Juan Jose Serna. Mr. Serna, you now stand charged yet again with burglary of a motor vehicle. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you.
On March 20th, 2025, law enforcement.
Right out of the gate, Miranda writes, "This isn't a formality, it's a warning label. Anything said after this point becomes evidence, not explanation. And in probable cause hearings, silence is often the smartest move, but rarely the one defendants choose."
Was dispatched to a burglary of a motor vehicle that occurred in Old Navy parking lot in Harris County, Texas. A law enforcement officer spoke to two witnesses who viewed the incident. The first witness stated that the suspect's motor vehicle pulled up the complaining witness's motor vehicle, and the suspect wearing a camouflage hoodie got out and pulled on a door handle of the complaining witness's motor vehicle, attempting to open it. That set off the alarm of the motor vehicle, and the first witness advised that the suspect got back into a car, drove off to another area of the parking lot, parked and waited for the alarm to stop alerting. The first witness stated that once the alarm stopped making noise, the suspect jumped back over to the complaining witness' motor vehicle, parked, and the suspect in the passenger seat got out and was able to make entry into the complaining witness's motor vehicle. The complaining witness advised that she was walking up to her motor vehicle when she saw a Hispanic male wearing a camouflage jacket sitting in the driver's seat of her motor vehicle. The complaining witness stated that the suspect saw her walking up, jumped out of her motor vehicle, got into the passenger side of the waiting vehicle with an unreadable plate, and the complaining witness then heard the male tell the driver, "Go, go, go." Another law enforcement officer advised he was patrolling when the gold Tahoe that the suspect was observed in passed him at a high rate of speed. Traffic stop was initiated, and the law enforcement officer was able to send pictures from the witness showing the suspect motor vehicle leaving the location to another law enforcement officer who was able to verify the suspect motor vehicle. After further investigation and search of the suspect, a camo jacket was found in the rear seat and a flat-pointed screwdriver consistent with the tool that would be used to break a lock on the complaining witness's door.
It was both that were attempting to B&B.
Yes.
This is where circumstantial evidence starts stacking bricks. A camouflage jacket that matches witness descriptions and a flathead screwdriver, the unofficial key of car burglars. No fingerprints needed. This is about patterns, tools, and timing.
The defendant is the registered owner of the vehicle, but the motor vehicle was displaying a counterfeit tag that did not come back registered to.
So Mr. Serna is the one that owns the Tahoe?
No, I apologize, Your Honor. Mr.
Yeah,
Serna is
gentlemen.
the second. It looks like he's second that was in the passenger, that was in the driver's seat whenever the complaining witness came out. Is not the owner of the vehicle.
Judge, if I may, the complainant or the witness stated that she saw a Hispanic male with a camouflage hoodie. When they were pulled over, there's two people in the vehicle. The camouflage hoodie was not on my client. So I'm saying that there's no probable
They
cause.
have both of them in the car.
This is classic defense strategy, identity confusion. Two suspects, one hoodie, shared vehicle. But here's the problem. Texas doesn't require you to be the only actor. If you're part of the sequence, you're part of the case.
Being car.
The both of them in the car.
That's what, according to you, right?
Yes, Your Honor.
Both individuals.
were in the car attempting to,
I had the,
Because I thought I read that one person wearing a camouflage hoodie was in the car. when
that was the
somebody-
second one. So the first person goes in, gets out, and then that's when the other one goes in. And then at that point, the complaining witness comes up and tells them to take off. Mr. Cerna, let's go through your stuff. Theft of wire or cable, theft, trespass, evading arrest, evading of a motor vehicle, theft, assault of a family member, attempted burglary of a motor vehicle, burglary of a motor vehicle, theft, third, burglary of a motor vehicle, unauthorized use of a motor vehicle, evading arrest in a motor vehicle, burglary of a motor vehicle, assault, possession of marijuana, robbery, felony theft, assault, a prior, now a felony, another felony assault, unauthorized use of a motor vehicle, tampering with a government record, felony theft, unauthorized use of a motor vehicle, and now open, you have unauthorized use of a motor vehicle, felony theft, burglary of a motor vehicle, and possession of a criminal. What on earth do we need to do?
This is the moment the courtroom temperature spikes. The judge isn't just listing charges, she's showing a pattern. When a rap sheet reads like a crime index, judges stop asking what happened and start asking, how do we stop it?
To keep our county safe. It's a rhetorical question, but I don't know what on earth we need to do to ensure that our county and our cars are safe. You live in Houston, dude. You don't live in Montana or Wyoming. People like their guns and they like their cars. And when you muck with the wrong person, they're going to shoot your ass dead. It happens time after time.
But he's due in felony court tomorrow for his felonies. His bond is currently set at 10,000 for this misdemeanor. Can we reset till Friday to see what happens in felony? I'm asking the court to not revoke his bond. His bond is set at 10,000. I'm asking the court to just keep it in place.
So there's nothing for me to revoke because he has not made bond on
In
the
felony, correct.
You're now being held at no bond on at least 2 of the felony cases that I see. If, I don't know if you're going to get out, but if you do, I'm ordering you to have home confinement. I don't want you out at all because you scare me, Mr. Cerna. You really do. You're not going to be in possession of weapons. On your other ankle, I'm going to put a SCRAM monitor so I know that you're not consuming alcohol. I don't want you using any dope. And let me be frank. If I find that you break any of these conditions on your bond, I'm going to make your bond so high you'll have teeth popping out. Do you understand? Do we have, who got the co-defendant? Do we have the co-defendant? No contact with the co-defendant, please, Felicia.
still loading.
That line, I'll make your bond so high your teeth will pop out. That's not theatrics. That's judicial leverage. Home confinement, SCRAM monitor, weapon bans. This isn't freedom. It's incarceration with Wi-Fi.
We have,
Say it again. You ever had a job before? A full-time job?
yeah.
That's probably a good idea. When you have too much time on your hands, you become self-destructive. So with this, it's just a matter of time, dude. It's either dead or 50 years, man. Really? Life's too short to live in a 6x9 box for the next 50 years. All right.
This isn't legal advice anymore. It's a prophecy. Judges say this when they believe the math is already done. Too many cases, too much risk, too little control. The court isn't threatening him. It's predicting the trajectory.
So I have talked to pretrial in regards to the violations as to tampering with the SCRAM.
You need a translator anyway, right?
I guess
Vicky
so.
Ramirez?
Yes. So pretrial doesn't know exactly what was tampered with. He does work in construction. He wears socks. He does suffer from this condition called neuropathy, where he has to put like this cream on here. He says that SCRAM actually has been causing him a lot of pain on his legs. So sometimes he shifts it to put the lotion or moves it. But since it was in the morning, he said it was probably like when he was at work with the boots. But there was no BAC, no alcohol, nothing. It was just
Because a lot
tampering.
of times the way they do it, they tamper with it so that alcohol can't be detected. They'll put something in between the leg and the monitor this is Enrique Ramirez.
This was,
A lot of times they'll say the tamper was from midnight to like 6 a.m. so that we know that there was something in between the leg or they've done something for that length of time. I don't know.
See the first one.
And it says alcohol was
began
detected.
on March 1st at 4:32 a.m., returned to baseline at 2:40 p.m. That tamper was 10 hours and 8 minutes.
Come up, Mr. Ramirez.
I don't see the second one. I see the one on the first.
I don't know what to tell you, Ms. Solis, but
oh, I mean, pretrial doesn't have knowledge as far as like what was the tampering. I mean,
they can't. It's impossible.
I know that, Judge.
All we know is that the device was not detecting his skin for a certain period of time. And at the same time, alcohol is detected. So let's do this. I need to get a translate here so I can properly translate and let him know what I'm going to do. Oh, Blasa.
Yes.
Can I borrow you for a second, please? No, I just need you to help me translate.
Oh, okay.
Mr. Ramirez, you were instructed not to tamper or remove the device. We have 2 tamper events here, where on March 1st at 6:33 a.m. and the second one on March 10th of 2025 at 11 a.m. Alcohol was detected on the first event. Alcohol was not detected during the second tamper event. That's what I have. We need to do something with this case. It's 207 days old and he's now tampering with the device. So
I know, Judge. I mean, we're ready for plea today, but
you're tampering with the device and you're consuming alcohol. Told you not to. Let's do this. I'll send it for a drug and alcohol test right now and he'll.
Judge, yeah, because he has no status. If he goes in custody, he will get a nice hold.
I have admonished you ad nauseum not to violate conditions, because if you go to jail, there will be serious consequences. And we now have tamper events and a positive alcohol rating. I am now going to send you for an alcohol and drug test right now. I want to know what, if anything, that you will test positive and you're to come right back.
Because he does say, he does use the creams on his arms and hands, so it doesn't have a BAC level or anything in regards to the SCRAM, so.
Advised of.
I understand, Judge, I understand.
All I know is that alcohol was detected and he's tampering with the device.
Judge, all right, well, so I'll step out and then, thank you.